Good afternoon, students from Deakin University, Masters of Business Sports Management. My name is Paul Horvath. Thank you for the opportunity to speak to you this afternoon. As you can see from slide number 3, it has my background. I've been practicing in the area of sports law for in the area of about 15 to 20 years. I have a master's degree in sports law from the University of Melbourne, where they have these days about 13 or 14 subjects. I've been heavily involved in a range of sports, including AFL and the Richmond Football Club, including acting in the Essendon Supplements case for Mark Thompson. And I've sat on a range of committees and boards, including the Board of Harness Racing Victoria, a range of disciplinary tribunals, the AFL Players Association Player Agent Arbitration Panel, as well as the various tribunals, including both Olympic winter sports and summer sports, as well as the Commonwealth Games, where I was involved in representing athletes who had appeals in relation to selection cases. And I've been doing a lot of these cases for about 15 years. I'm heavily involved in a range of anti-doping cases, and I've got some going at the moment. The popular or common supplement or drug at the moment seems to be something called Ligandrol, LGD4033, which relates to Shana Jack, and also a number of athletes, both nationally and internationally. And it seems to be a substance that's particularly possible to have inadvertent taking of it, whether it's through a tainted supplement or through some other source. And you can see the general nature of our sports practice that we're involved here at SportsLawyer, governance, constitutions, policies and bylaws, as well as the disciplinary tribunal matters, and also child safety in sport, which relates to drafting child-safe policies for sporting organisations and ensuring that children are safe in sport, particularly given the findings of the Royal Commission into child sexual abuse that came down in 2017-2018 and identified various priests, the pinnacle of which was Cardinal George Pell and his various court cases. So those are some of the matters that we're involved in here. Today, my presentation intends to cover the points that are on your page there, which is the role of law in sport, the role of agents in sport, and key legal issues that arise in athlete management, which includes contracts. And there's a variety of contracts. Obviously, there's the athlete contract with their sport. Athletes have a separate contract, as you will know, with their agent. And then there's a range of other contracts, which is broadly includes anti-doping rules and so on. They're actually contracts. And also the rules relating to, say, agent accreditation. That's a contract between the agent and the sporting regulatory body. And obviously that spills over to integrity, so there's anti-doping policies, there's match-fixing policies, loosely child safety policies falls within that area of integrity. Accreditation I've touched on a moment ago, and there's various rules which are applied from time to time in relation to athlete or rather agent breaches of the rules, and we'll touch upon some examples later on so that I can give you a concrete indication of how this applies in reality. Deregistration obviously is the serious end of accreditation and the application of those rules. And then I want to talk to you about some case studies concerning all of these legal and quasi-legal issues. But I should just say that the purpose of my presentation today is not to talk terribly legalistically, but rather I'd like to talk more broadly about how you as agents might come across issues that arise. I'm not going to talk about Section 4 of this particular rule or something like that, but I just want to talk about the things you need to look out for and concerns that might prick your interest when you're acting as agents. And I suppose in that sense, in the governance speak, it's your risk management of these issues, things that can go wrong, things that you should be alert to in being good and diligent athlete managers or sports managers. Next slide. So the role of law in sport. The relationship between sport and the law is always changing, as we know. COVID-19 tells us that. There's been rapid and significant changes this year. And the two things are becoming more intertwined. Obviously, the professionalisation of sport. We've had a sudden growth of the number of women professional athletes in recent years with AFL women's competition, the professionalisation of women's cricket, the professionalisation of women's soccer, and so on. So the number of professional athletes have increased dramatically in the country. And so along with that, the number of rules, regulations and disputes is naturally going to grow and increase with that. So as per what's on your screen, some of the issues that come up are drafting and reviewing player and agent contracts. I should say that most of these contracts with the biggest sports are standard contracts for which the terms and conditions are generally non-changeable. So you will see those contracts and you do not generally get an opportunity to make changes to those contracts. The only changes that may be possible is in the schedules to the contracts, which might be the dollar terms, where there might be a breach, payments under the contracts, performance-based bonuses and the like. And similarly, some of the agent contracts have a fixed fee. It might be 3% in the AFL is a standard commission for a AFL player agent on their playing contract. However, generally their payments in relation to sponsorship type agreements can increase up to 15, 20, 25% might be the type of commission that the agent might receive in relation to those sponsorship type contracts with players. Often as a lawyer you're involved in drafting policies for sports, codes of conduct and codes of ethics. The policies are very important because they set out the rules and they particularly cover when disputes arise, and we only see the importance of the wording that goes into those policies when the disputes come about, and then every single word becomes important and how the policies apply. We have anti-doping and anti-doping violations and anti-doping policies, which are common in this practice. They're very savage, I suppose, in terms of the consequences for athletes, because certainly since about 2015, the standard period of suspension for an athlete for an anti-doping violation is a starting point of 4 years. If it's a supplement in the nature of a less serious substance which was not known to be present in, say, a pre-workout supplement, or if it's cannabis or something of that nature, then the maximum may be as little as 2 years, and the starting point might be 0 up to 2 years. But with the serious drugs such as the Lagandrol I was talking about in the Shana Jack case, the starting point is 4 years. So your starting point is, the presumption is that you get 4 years, and then the penalties reduce if you can show how the supplement got in, or the substance got into your system, and then that you did not intentionally take the substance. Sport in the law involves representation of athletes before courts and tribunals. We'll go through some examples of courts a little later on, not necessarily to do with sport, of course, but the Israel Folau was a sports-related case, but again not related to his performance on the field. So more often than not, the cases that go before the courts don't relate to on-field behaviour, it's off-field issues. Israel Folau is an athlete contract issue. Other issues can be player misbehaviour. I think it was Jack DeBellin in the National Rugby League last year was a major issue as to whether or not he could be suspended ongoing until his case went to court, because I think serious sexual assault matters, a new rule was introduced to say that the player could be stood down indefinitely until their case went to court, and that was upheld by the courts. As I mentioned, governance is all important. I think that's probably going to be something that's going to be changing all the time at the moment under COVID. Boards and organisations are going to have to be very adaptable to the circumstances. There's been significant financial losses. We're involved in some AFL clubs, and obviously they're cutting in the region of 75 to 80% of their staff being stood down, and then the remaining staff might be reduced to working 1 to 2 days per week. So the funding has just been cut out of the AFL industry, and probably that's not going to resume back to something like the normal full-time of most of those staff until well into next year, given that we're expecting no crowds. I've touched upon sponsorship and media endorsements earlier, acquisitions and disposals, intellectual property rights which allow people to gain extra money, which is probably related to sponsorship and media endorsements. Dispute resolution, which can involve arbitration and mediation of a range of issues, which might include, say, member protection policies. And member protection policies are mechanisms for, say, bullying and harassment allegations, which are relatively common in sport, that might be dealt with in your elite sports, whether you're involved in basketball, whether you're a sports administrator, a coach, or someone else, a team manager who's involved in some sort of a dispute, is bullied or is undermined in some way through the sport, and that you seek some sort of dispute resolution. If it doesn't resolve, then the case can ultimately end up in a tribunal hearing. And the other types of disputes that we've seen dealt with in that fashion include sexual misconduct in similar sports, basically elite and Olympic type sports, where sexual assaults are dealt with under member protection tribunals, and people might be suspended or some other penalty imposed on them for inappropriate conduct towards children in their sports. Injuries and accidents come up, and we've seen in recent times concussion being a very live issue in sport all over the world, and we've touched upon child safety and the Royal Commissions and consequently the child safety policies that are introduced, and part of the mechanism for that to be dealt with under state Victorian governments is the working with children checks. What is the role of the agent in sport? As an agent, your job is to control and promote the athlete. This includes incursions into the athlete's personal life and behaviour. There's rules and there's certainly expectations as well imposed by the public on athletes. And I guess part of the view is that because they are in a number of cases well paid for the way that perform their sport and get to, I guess some people say, have a dream job and are paid good money, obviously well above the average wage in, for example, the AFL, where the average wage is in the region of $300,000 a year. People think that they're entitled to know a bit about an athlete's personal life and or to review their behaviour if it doesn't meet community expectations, whether that's through an assault or a drink driving that might occur outside work hours. Agents also have to follow various rules, policies and legislation that apply to sports. This area of agency is growing more complex as time goes on. I think an example would be in soccer, which is regulated by FIFA internationally and Football Federation Australia in Australia, that agents now are coming to be more regulated in the way they conduct themselves, which in part provides protection to the athletes, to the players who might be young, who might be vulnerable, who might be naive, and need to rely on agents to secure contracts for them, some of which may be very valuable in terms of setting that person's career up for the future, but at the same time the athlete doesn't want to be locked into a long-term contract which might be unfavourable to the athlete but favourable in the short-term interests of the agent to secure funding, and so having agent accreditation schemes helps to balance up those interests. Agents need to seek legal advice from time to time when faced with some of the challenging situations that we will talk about, and these are many and varied. So there's a few examples, contracts, the handshake there. In the old days things were done by a handshake agreement. These days there are almost no contracts that aren't committed to writing, because unless it's clear and known what each party is getting out of the contract, then it's probably not worth being involved in the contract. And we saw Sonny Bill Williams in 2004, I think it was, tried to get out of his then contract with the County Bankstown Rugby League club by walking out and going to a rugby union club in France, and the court said, no, you can't do that. You had a written contract, we're going to hold you to the contract, and ultimately he was being paid around $400,000 a year then. He had to pay about $750,000 to Canterbury and to the National Rugby League to settle his removal out of that contract, and then also had to agree not to play rugby league for the following 3 or 4 years, which saw out the contract that he had signed, and then subsequently he went back to play rugby league. I think it was with the Roosters, and might have even joined the premiership side after that, but these days is back playing rugby union. But contracts are everywhere in sport and crucial, and if in doubt, you should always have a written contract to make sure that you get what you bargained for, and you're also clear on the terms if anything should go wrong, because there's many situations where things can go wrong. But I don't want to sound like the prophet of doom, as lawyers can tend to sound, but it is important that you allow for things that are unforeseen or things that might go wrong, and therefore if something does happen, okay, we look at the contract, this is the way it's dealt with. Whether there's a disputes procedure, whether there's a mediation process, whether the contract comes to an end for force majeure, which is some unforeseen circumstance that might bring the contract to an end, which could be COVID-19 or it could be some other circumstance. And then we can see the media there, which is obviously very important in a range of sports, particularly the professional sports. I can think of some athletes in swimming that have been quite regularly in the press, such as Nick Darcy when he was in trouble in 2007 and 2008, which saw him kicked off the Olympic team that was to go to Beijing, and then obviously charged with bringing the sport into disrepute, and also assaulting Simon Cowley, another former Olympic swimmer, and being convicted of criminal charges there. So the press gets involved in these things, and later Nick Darcy was also seen holding some guns in a gun shop in America with another Australian swim team member, which was also saw him subject to disciplinary action. Then we've got the picture of the police lady there, and we'll talk about some examples in a moment. So contracts in sport. As an agent, you'll be responsible for managing and negotiating your athletes' contracts. You need to be aware of the key terms, concepts and clauses, athlete-agent contracts and sport-specific regulations you'll need to obviously commit to. As an athlete agent, you are agreeing to accept the rules of particular sports, and also with your athlete you agree to provide certain services and can be held to account for those things. We mentioned earlier that there are standard playing contracts, which are in different sports written in different ways. The contracts can be just with the league. So I think, for example, in cricket, the contracts are signed with Cricket Australia. In rugby, the contracts may be signed with Rugby Australia. And then in sports like the Socceroos might have a contract with their club, be it in Europe, Asia or Australia, and then they might have a separate contract and collective bargaining agreement, indeed, if they're a member of the Socceroos or Australia's national team, which plays at either the World Cup or the Asian Federations Cup. So there's different types of contracts that players enter into. In the AFL, it's a three-way contract between the player, their club and the AFL, so it's a three-way or tripartite agreement. Collective bargaining agreements are important in those bigger sports. That includes netball, that includes cricket, that includes AFL women's, and obviously the collective strength of the players is important, and that certainly helps bring about the best terms and conditions for the group of players, and protects a range of players' rights. Usually the highest paid players are okay because they will be paid quite well through their contracts regardless, and it's usually the lesser players who need to be protected through the collective bargaining agreement by getting minimum rights, minimum terms and conditions, ensuring that their injury insurance is paid for, their health insurance is paid for, and those sorts of minimum things, so that if anything is to go wrong, if they get injured, then there's some level of compensation and management in place for them. All sorts of health provision through the athlete associations, player associations and so on. And those associations also provide a range of support that could be assistance, and we've seen this week with Dean Laidley as a former player and indeed coach, the AFL Players Association agreed to pay for him to go into a 28-day rehabilitation program, which I believe is for drugs of addiction as well as other conduct. I'm not sure if it was gambling or some sort of addictive behaviour, but in any event, the player association there still assisted him, even though he'd been out of playing for many years and had been a coach for many years. They provided that assistance in getting into that program. Sponsorship agreements are a big type of area for agents, because I think that that's an area which really enhances, and obviously some degree of profile athletes. It's said that the players, for example, in parts of Perth and Western Australia who might be in the AFL system, very popular there because there's only a small number of players, and so the first 10 or 15 or the top 10 or 15 players on, say, the West Coast Eagles list all get some sort of sponsorship, whether it's by a motor vehicle yard or manufacturer or something like that, whereas that wouldn't necessarily be the case here unless it was a more direct club sponsorship, say with Richmond, who gets sponsored by Jeep, and a number of vehicles get provided to the club from Jeep. But again, it's probably the top 3 to 5 players there who get sponsored, whereas the sponsorship agreements, as I say, in the towns where there's a lot less teams, be that Brisbane, be that Perth, be that Adelaide, there's a lot more sponsorship opportunities because the players stand out a lot more, because there's 10 AFL teams in and around Melbourne, there's 2 in Adelaide, there's 2 in Perth. In amateur sport as well, there's athlete membership contracts, so that's the athlete's agreement with the sport. I've touched upon the member protection policy earlier. That's to do with child safety, that's to do with different types of bullying. It could be cyberbullying, it could be abuse of umpires or referees that takes place through social media and breach of social media policy. And there's the rules and policies of the sport, which includes the doping policies. And all of these contracts, as managers, you need to have an awareness of, and you need to assist the athlete in navigating their way through these rules and potential breaches. And things can go wrong, breaches of rules can happen. Sometimes that can happen unknowingly. Sometimes breaches of the rules are innocent. And I think it's fair to say that breaches of things like your anti-doping policy are much more serious and should not so much be happening accidentally, because you should be very, very careful about what supplements you're taking and what goes into your body. As ASADA tells athletes, it is the athlete's responsibility for whatever goes into their body, and it's not necessarily an excuse just to say, well, the club doctor or the team doctor told me that I could take this. That won't necessarily get you a defence when you're facing the Court of Arbitration for Sport on a charge where you're looking at 4 years suspension. So it may be that legal advice is helpful when you're negotiating all of these types of contracts, or you come into a situation of potential breach. What are some of the key contractual terms and clauses to be aware of? I touched on earlier force majeure, which is an unexpected and unanticipated event outside the experience or knowledge of the parties, which wasn't something that was on the horizon when the contract was entered into. We typically think of floods, fire, and things of that nature. The force majeure is normally written into a contract and can bring the contract to an end. And in contrast, there's the doctrine of frustration, which applies regardless of whether it's written into the contract. And frustration just says, well, if you've got a contract in place, it's going to put the contract on hold while the frustrating event continues. So if it's the COVID-19, we know that the COVID-19 event will come to an end, whether that's in 3 months or 6 months or 9 months, depending on what the restrictions are in the particular sport. And then the contract will ordinarily resume if it hasn't already expired. There can be morals clauses about bringing the sport into disrepute. That's very common these days. We've seen that in plenty of examples. Israel Folau is one example. I mentioned that in the Nick Darcy case, which was a 2008 case that went to the Court of Arbitration for Sport, and I'll also talk to you about a case I was involved in which went to the Court of Arbitration for Sport in Switzerland about bringing sport into disrepute and what needs to be proven in those sorts of cases. But it's very common to say someone brought sport into disrepute, and so that's considered a fairly serious breach depending on the nature of the conduct, and serious consequences can flow. Rules are presently in plenty of the sports about underage athletes, and for example not being able to sign an underage athlete before the draft stage, so not tying athletes in and so that they will commit to your particular team when they reach a certain age, so that they're able to be drafted by anyone, and that includes the agents. Very serious penalties apply in the US about that for amateur athletes. Whole colleges have been struck off college football programs for 1 or 2 years for breaches of those types of rules and payments to players underage and so on, and to their families. Sponsorship agreements, that relates to the use of the athlete's image. It might depend on the sport. The athlete may not be able to use their standard uniform without permission during events such as the Olympic Games. We know that most of the time the athletes can't put their sponsorship logos onto their athletes during the period of the Games. Whether you are a tennis player such as Serena Williams isn't allowed to show her sponsor. She'll have tape blacked out over her sponsor agreement on the front of her shirt because it might compete with all of the other sponsors in the Olympics. And the Olympics will know very closely guard their sponsors and give them great protection. And take legal action for those that don't follow the rules, and that's why the Olympic sponsorships are of such great value, and they sell for billions of dollars. I think in the end that that's not the company. It's the American company. I know it's got a name in it, which holds the majority of the rights and sometimes dictates whether the swimming finals are held in the morning or the afternoon. And then there's restraint of trade clauses. Those might prevent an athlete from going to play or participate in another sport for a particular period of time. And an example of that I mentioned earlier was Sonny Bill Williams had a restraint clause that he couldn't play in Australia once he settled his case. Other restraint clauses prevent athletes from signing up to another team unless they fulfil their obligations under their athlete contract. And they're not uncommon in sports. Sometimes it's said that doping penalties and other disciplinary penalties can operate as a restraint of trade, and people take those to court, or may take them to court, to argue that they shouldn't be applied because they're unfair. And sometimes those arguments are successful, and there's some famous examples in soccer, which has led to major changes to the athlete contracting system. So integrity is a very big talking point in this day and age. Agents need to be aware of the various policies which are the sources of integrity in sports. Some examples include the World Anti-Doping Agency Code. I think we will talk about the WADA code, but typically if you're representing, say, a swimmer in Australia, you'll be applying the Swimming Australia Anti-Doping Code. You won't be applying the WADA code, but what it will be is it will be a WADA compliant Swimming Australia Anti-Doping Code. So in order to be approved within the Australian system, it would be submitted to ASADA, who would tick off that the anti-doping policy complies with the World Anti-Doping Authority Code, or the WADA Code. So all of those policies, AFL's anti-doping code, Soccer or Football Federation Australia, netball, all of their anti-doping policies comply with the WADA Code. So that's what we mean by the WADA Code. But normally it'll be I am being punished under the netball anti-doping policy, the swimming anti-doping policy, and so on. Then there's the AFL Players Code of Conduct as an example, Rugby Australia Code of Conduct, etc. You have your member protection policies. Those are policies which are put out and written primarily through Sport Australia for the benefit of all the elite sports. So it's a template that is written and is required to be adopted by all of those national elite sports. So they must have a member protection policy in place for the protection of, I think originally it was envisaged that there's a degree of protection for children, there's protection against bullying, there's a protection against harassment, and there's certain policies that apply to people such as coaches, team managers, and even the athletes, to regulate the behaviour and have a way that people can bring complaints, whether you're a member of the public, whether you're a parent, whether you're someone who's at a pool complex when a swimming competition. It gives you a channel of complaint to lodge or raise an issue with the sports body, to bring someone to account and to be held to account for improper and unacceptable behaviour. So you must have that as part of your affiliation to Sport Australia, which usually involves hundreds of thousands, if not millions of dollars of federal government funding, and as a condition of that funding from the federal government, you must have a member protection policy at the national level, and then generally that flows down, and the state members within that sport must also adopt a member protection policy. And then so there's the national template, and then there's also a club template which is put out by Sport Australia, and a number of clubs have their own member protection policies, and people can lodge complaints under those policies. And just as a side note, we know that the recently commenced, and I think it started on the 1st of April, National Sports Tribunal can deal with some of those member protection issues these days, whereas in the past it had to go to the sports own tribunal, and perhaps appeals might have made their way to the Court of Arbitration for Sport, which is very expensive, but now we've got the National Sports Tribunal, which is run by the government and is said to be a very cost-effective alternative and option for dealing with those sorts of disputes, where there might be bullying, there might be sexual harassment, there might be child safety issues that you want to bring to the attention of your sport. Then there's codes of ethics and conduct, which apply in various sports, and you need to be aware of because of the potential that if you breach or fall foul of those ethics and conduct policies, you can get in trouble for. An example of that might be the gambling policies, say in the AFL. I've represented a journalist who was caught and charged with a breach of the betting rules, and then they were suspended from being able to call games and hold their accreditation within the AFL for a short period of time, because they had breached that code of conduct which related to gambling in that sport, even though it wasn't intentional. There's a real message that's sent in relation to gambling, both to players and other stakeholders within the AFL, particularly in order to protect their sponsors, which might include the gambling agencies, and to show that they take integrity of their sports very seriously. So the policies seek to control the behaviour of athletes both on and off the field. And what happens if your athlete is accused of bringing sport into disrepute or is charged with an anti-doping violation? And an example of bringing sport into disrepute was Nick Darcy, as I said. He was selected by winning the butterfly event in 2007 and qualifying with the fastest time to go to Beijing. And that night went out to celebrate with a number of swimmers. He was at a bar, got into an argument with Simon Cowley, and the allegation is that he elbowed him in the face, breaking his nose, and it was said that that was enough to bring the sport into disrepute. He was in breach of his team membership agreement and was therefore removed from the team. And he argued and sought to appeal that unsuccessfully. He had 2 appeals. And ultimately there's different stages and levels, and it was very easy to prove in that case that he caused disrepute, because the Olympic team agreement says you can be guilty of bringing the sport into disrepute either by bringing the Australian Olympic Committee into disrepute, your team into disrepute, the sport of swimming into disrepute, or yourself into disrepute. And so in that case, the Court of Arbitration for Sport got as far as bringing himself into disrepute, and they said because he was drunk at the time that he engaged in the behaviour, he had brought himself into disrepute and didn't need to go any further in that anti-doping policy. So those very wide anti-doping policies are very easy to breach. Integrity breaches will be responsible as an agent for communicating on behalf of your athletes to various individuals and agencies when something happens. In the Lockie Hunter case recently, there was criticism of the player and his teammates for not contacting the club straight away and seeking legal advice, and that was one of the reasons that he was punished a bit more heavily and he was stripped of the vice captaincy. And so as the agent, if the player contacts you, you need to know when to seek legal advice. Clubs would say that you need to contact them first. You need to contact whether it's the operations manager at the club, the coaches and others, and then know what to communicate to the media in relation to what's happened with the players and the speculation that may be going on about the circumstances. So in that case, during this COVID crisis, Lockie Hunter had smashed his four-wheel drive SUV into 4 cars parked in Middle Park. He fled the scene by the time police arrived, and then was arrested at the home of another player from his team half an hour later, and tested positive for drink driving. And in that case, he hadn't contacted the club, so I think the club found out through the media. And unfortunately the player got other athletes involved, and they were charged with breaching social distancing and helping him try and avoid the authorities. So that wasn't seen as a great approach by the club. In this case, we've got, I'll just show you a quick video. This is a case I was involved in. So this is Mikhailo Zubkov, who in 2007 was here with his daughter. That's his daughter he was struggling with. She just told her father, and her mother was, I believe, on the phone back in the Ukraine, that she was seeing a boy back home that the parents had forbade her from seeing. So because of the father's conduct there, he was charged with bringing the sport of swimming into disrepute following that altercation. That was in the pre-warm-up room outside the 2007 swimming championship, World Swimming Championships in Melbourne. We had a hearing here in Melbourne. He received a lifetime ban for that conduct. It was said that he hit his daughter, but ultimately the Court of Arbitration for Sport in Switzerland found that there was no contact between him and his daughter, so that he swings a towel, but he never makes contact with her, so he never actually assaults the daughter. The police sought an intervention order in that case, and that was withdrawn the next day. But on appeal, his lifetime ban was reduced to an 8-month suspension, and we had to fly to Switzerland to have that hearing. But one of the important things the court said there is the swimming or FINA swimming's international body said that the athlete had to actually bring the sport into disrepute. So it wasn't a clause which said likely to bring sport into disrepute. It said, the wording was along the lines of brought swimming or FINA into disrepute or censure, and no evidence was put forward of disrepute in the sense that people thought less of sport. People started to take their kids out of sport because of that conduct. And the Court of Arbitration for Sport accepted that there was no actual disrepute in that case. And so what he was found guilty of was a lesser charge of general misconduct, and he received his 8-month ban in relation to that. Managing the media is a crucial one. I've had a bit of advice given to me through a law firm I worked at where we had a media manager. And I guess athletes such as the Rocky Hunter example, people are going to get in trouble, charged with a criminal offence, may have breached a contract or code of conduct, and the media may want to speak to you. So whether it's getting media management advice or legal advice could be helpful. The sorts of general tips I say is generally say little to the media prior to the charges being heard, as it could be used against your client's interests. It's okay to say my client will vigorously defend the charges unless you want to say exactly what you're saying in court to the media, which is just to be consistent in terms of what you're saying to the court and outside the court. So care needs to be taken as to what's said and limiting what you do say. The media want a few words or photo film footage. That's important to know. So by trying to run away from the media, it can be a bad look, whereas by just working out a few words, 1 or 2 sentences to the media, it can minimise the adverse attention and just gives the media what they want, which is a little bit of footage to go on the television, and then they're happy and away they go. As I said, allow the camera to follow you up the street, otherwise you look guilty if you're scurrying away. And it's often preferable to have a few brief prepared comments to give to the media. In terms of accreditation, that's obviously very important in terms of managing athletes. There's a variety of accreditation processes within the AFL and in soccer. You can see that it's about $3,300 and a 2-day process in the AFL, and it's about a 6 to 8 week process costing $1,800 in soccer under the FIFA accreditation system. Deregistration can happen. Ricky Nixon was one of those cases. Obviously his was quite serious. He was involved in the so-called schoolgirl scandal, where he'd taken drugs. He was filmed taking drugs with a young girl, and alcohol and so on, and also acting disreputably. He was suspended for 2 years from being a player agent, and I think he's since been back in the industry. I sat on not a deregistration case, on a agent arbitration case where the agent had not returned monies he'd obtained under athlete contracts to those athletes, and was asked to draw a decision as to whether or not the agent had acted properly in that circumstance, and so that was an interesting case, and basically found that the agent there had breached the rules, and was ordered to pay the monies owing back to those athletes, and then that decision was used to get a judgment in the courts against the agent, and so the decision itself wasn't enforceable, but once it was registered in the magistrate's court, it was enforceable to get the money back to those athletes. Look, there's plenty of cases that we can talk about, and I've touched on some of them already. In front of you, there's a range of athletes, most of which I've been involved in terms of advising clubs mainly, some of the individuals through the clubs, and some of the situations. Dustin Martin, in this case, was Chopsticksgate that we heard about, where it's alleged that he approached aggressively a female in a restaurant, and ultimately most of the charge was thrown out and he was given a suspended fine in relation to that conduct, and it was said that the allegations were wildly exaggerated there. Steve Johnson in 2007 was charged with being drunk in a public place in a country Victorian town. We had those charges thrown out, and nonetheless he was suspended indefinitely originally, and then it turned out for about 6 or 7 weeks and went on to be the Smith medalist in the grand final that year. So he really bounced back and turned his life around. And there's cases of misbehaviour of a few other athletes there. Andrew Lovett I've mentioned because he was charged with the serious sexual assault case, and rather than, I guess, conducting an immediate investigation, St Kilda terminated his contract immediately, and then the case went through a long-winded legal process, I think for 9 to 12 months when it ultimately settled. But the lawyers would tell you, stop, you've got to negotiate, you've got to work out a payment to Mr Lovett, but the commercial drivers come first sometimes in sport. So the club says we've got to protect our sponsors, and so we're not associating ourselves with a person like this. And so they terminated his contract and terminated any contact with him, and I guess they just thought, well, whatever the judgment comes down, we'll just have to meet that cost of his contract later on. And so that's the way the case played out, rather than the lawyers saying this is the right way to settle and negotiate the case. And Chris Yaron had his contract terminated at Richmond Football Club. Dan Connors had his contract terminated. And Kane Johnson was caught urinating on a police station after his 30th birthday, and was very remorseful when he went to the court and received a diversion order. I've just gone through the Steve Johnson case. I guess we need to think about, if you were representing the player, how would you manage the case and how would you support the athlete? And I've also just touched upon Dustin Martin's circumstances and the fact that he was largely cleared, as I say, through a police investigation which said that he committed no offence, and indeed the AFL even investigated the case. I think Richmond referred it to the AFL to investigate independently of the club itself. So the relationship between law and the sport grows closer. There's all the considerations of the law and policies and contracts we've talked about that you need to be aware of. You need to carefully consider these matters and speak closely with the operations managers or media managers of your sport and or your club. Be aware of your responsibilities as an accredited agent, because you'll be scrutinised for your conduct, and misconduct could lead to deregistration, and know when to seek legal advice, because there will be times when you're involved in contract negotiations or player conduct, which could be criminal conduct, or conduct that may go before a court or tribunal, when you'll need legal advice to get that right. Please submit any questions and we'll be only too happy to answer them. Thank you for your time.
Oh, go to the next screen or something maybe.